What are the top 3 workers' comp adjuster tricks in Massachusetts? Hi, I'm attorney John Sheehan. Since 1993, I've been fighting on behalf of injured workers throughout Massachusetts. I fight to make sure that injured workers get the financial compensation and medical treatment that they're entitled to without getting taken advantage of by an insurance company. Well, I would say right at the top of the list as far as insurance adjuster tricks in Massachusetts is trying to get an injured worker, especially a worker that's not represented by a lawyer or not represented by an experienced workers' comp lawyer, to get the injured worker to sign a form called Agreement to Extend Pay Without Prejudice Period. In my opinion, it's almost never in the interest of the injured worker to sign an agreement to extend the pay without prejudice period. Briefly, the pay without prejudice period is 180 days or 6 months that the law gives the insurance company at the beginning of a workers' comp case to start paying workers' comp benefits. During that time, during the pay without prejudice period, the insurance adjuster can end the benefits, terminate the benefits, or reduce the benefits. Take the employee, for example, from total benefits down to partial benefits. And they can do all that without having to go to court, without having to go to the Department of Industrial Accidents in Massachusetts to get permission from a judge. The only thing the insurance company has to do is to fill out a form from the Department of Industrial Accidents, mail it to the injured worker, giving them 1 week's notice that either their checks are going to end or they're going to get reduced, or maybe reduced significantly. So by asking the injured worker, trying to get them to sign this form, the insurance adjuster is actually trying to double the period of time to a full year that they're in complete control over whether you get your check next week, whether you get your check next month. And in my experience, in speaking with injured workers who hire us to help them, most insurance adjusters, almost all of them, don't explain what the injured worker's rights are. And why would they? That's not the adjuster's role. The adjuster's role is to try and pay you as little as much money as possible, to try and stop your workers' comp as soon as they can, make you go away, so that the insurance company can go on and make more money. Now, another trick that I see, and this involves a little work between the insurance adjuster and your employer, and trying to put pressure as well on your treating doctor. And they'll use nurse case managers that are employees of the insurance company to do this. And that trick is to try and get the doctor, your doctor, to release you to light duty early, even though you're still injured, even though you're still in pain, and you haven't received all of the treatment that you need, and to release you to what's called light duty. And then they'll try and get your employer to make you an offer, to make you a job offer, a light duty job offer. The problem is, in most cases, it's not a legitimate job offer. It's just something that they came up with just to be able to get you off the books of workers' comp, to stop your workers' comp benefits. They lull you back to work with the hope that you're going to be there working this light duty job offer. And then in some cases, you'll find that it really wasn't a light duty job offer. They're practically expecting you or pressuring you to do your regular job, or it's a light duty job offer for just a limited period of time, even though your physical restrictions from your injury are ongoing. So they might pressure you to either go back to do your regular job and get hurt again, or they'll tell you if you can't do that, then bye-bye. They'll lay you off. You'll be on unemployment. So you'll be out of a job, you'll be out of workers' comp benefits, and then you'll be receiving unemployment, and you might not have access to get more workers' comp benefits if you're not able to go back to your full duties before the accident because of your injury. A third trick that I see frequently as well, especially at the beginning of the case, is that they'll just deny the claim. The insurance adjuster, without doing a thorough investigation, without getting all of the medical records from your treating doctors, will just simply send out a denial, claim denied. And what are they hoping? They're hoping that you'll just go away. And the insurance companies have all of the statistics. They analyze all the statistics to know what the chances are that a certain percentage of injured workers, even though they're injured, even though they were legitimately injured in a work accident and they need medical treatment, there's a certain amount of them are just going to let it go. They're not going to do anything. They're not going to go to the doctor. They're not going to contact a lawyer to see what rights they have to workers' comp benefits. They may either go to a different job, maybe it's less money, it's not as physically demanding, but it's going to pay them less, or they'll go on unemployment if they can't work, and not pursue what legitimate workers' comp benefit rights they might have. If you have any questions about workers' comp benefits in Massachusetts, if you're receiving workers' comp benefits, if your benefits have been recently denied, terminated, or modified or reduced, I'd be happy to talk to you to see in what way I can help. And you can either call me at the office, you can send me an email, you can visit our website where we have contact forms, and you can see the client reviews that we have and the results that we've been able to achieve for other injured workers. And if you find the information in this video helpful, please like the video, click the subscribe button, and click the bell icon so you'll receive notifications of my future videos. And by all means, please share the video with your friends and family.